Again, we want to thank you for joining us here today for our breakfast between Pro Home and the Taunton Area Chamber of Commerce, featuring Mass Gaming Commission Chairman Steve Crosby. I'd also like to take a moment to thank our sponsors, Anytime Plumbing and Heating and the Career Insurance Agency, for their generosity in sponsoring this event. I'd now like to introduce Kerry Babin, the President of the Chamber of Commerce, to say a few words. Kerry.
Thank you, Joe. I would now like to introduce Chairman Crosby. Chairman Crosby was appointed in December by Governor Patrick as the first chairman of the Mass Gaming Commission. Prior to serving as chair of the Gaming Commission, Mr. Crosby served as founding dean of the John W. McCormick Graduate School of Policy and Global Studies at UMass Boston. He has 45 years of experience in policymaking, entrepreneurship, nonprofits, and academics. The chairman previously served as the Secretary of Administration and Finance to Governors Cellucci and Swift. Please welcome Chairman Crosby.
Thank you, Carrie. It's really an honor to have this position. And just to give you an idea of what an honor it is, my wife and I were walking down Center Street in Jamaica Plain last night. We were looking for a restaurant and came across two of our neighbors and that we hadn't seen for a week or two. And one of them came up to me and shook my hand and said, "So have you been indicted yet?" It's a very low bar. One of the political commentators said that things were going well with the Gaming Commission because nobody's been indicted yet. So I hope we can keep to that high standard of performance. Thank you all for having me here. I know this is really a hotbed of interest and action and aspirations, and hopefully in due course, economic development. Unfortunately, I'm not going to be able to answer a lot of the questions that you probably have because of this unusual situation where Region C, Southeastern Mass, will be controlled by a compact that is negotiated between the governor and the tribe. But I can talk a little bit about what we're doing, and I think that will be reflected probably quite a bit in the compact. For starters, let me just tell you a little bit about the commission itself, the Massachusetts Gaming Commission. It's an unusual body, 5 full-time commissioners. There are no other commissions in the Commonwealth that have full-time commissioners. Besides myself, there's a former judge. Some of you have met him. Jim McHugh was an appellate court judge. There's Bruce Stebbins, who's a former city councilor and economic development professional from Springfield. There's Enrique Zuniga, who is a Yale Business School graduate and had a lot of experience in real estate development and ran the Water Pollution Abatement Trust for Treasurer Grossman. And Gail Cameron, who is a retired lieutenant colonel from the New Jersey State Police. She was the number 2 person in the New Jersey State Police, where she, among other things, was head of the organized crime unit and head of the gaming unit. So we have a really interesting, broad base of experience. None of us knew I knew Jim McHugh a little. None of us knew, beyond that, none of us knew one another. So in addition to everything else, we're getting to know each other and learning how to work together. And we operate, because many of you are elected officials, town officials, select people, you know the open meeting law requirements that you can't get a quorum together and talk about any business. Basically, you can't get a quorum together and talk about anything without formally having a public meeting. Well, we are 5 full-time commissioners who sit right beside each other all day long and can't talk about much beyond 2 people because of the open meeting laws. We can't talk about whether we're going to put a new carpet down without violating the open meeting laws. So it's an awkward environment that we're trying to adapt to. But it's a great group of people. We work together really well. And I think the appointing authorities, the governor, the attorney general, and the treasurer did a really good job, at least of the other 4. We'll see about me, at least I'm not indicted yet. You know the Commonwealth is divided up into 3 regions, A, B, and C. This is Region C. And the authorizing legislation, the expanded gaming legislation that the legislature passed and the governor signed, after, as somebody here, who's the gentleman here who owns Raynham, or the family owns Raynham? I walked in with, yes. He's talking about this has been going on for 20 years or whatever, but finally the legislation got signed. They divided the Commonwealth into 3 regions and authorized up to 1 casino in each of the 3 regions. And the words "up to" was important. We don't have to have a casino in each of the 3 regions, but we may have as many as 1. And also the legislation authorizes 1 slots parlor anywhere in Massachusetts. There's no region designated. The Region C is controlled by not the Gaming Commission. The legislation lays out, and I'll talk a little bit about this, pretty clear parameters for what the legislature and the governor felt that they wanted reflected in our actions and in our decisions. The Region 3 will be managed not by the Gaming Commission, but by the terms and conditions of a compact between the state, being negotiated by the governor, and any Indian tribe that gets authority to negotiate. In this case, so far, it's just been the Maggie Wampanoags. It's a confidential negotiation. The reason for it, you all maybe are familiar with this, but when the legislature and the governor knew that there was always going to be a possibility that one of our Indian tribes, most likely if it was going to be a tribe, it would be the Magpie, because they were the most advanced in terms of their status with the federal government, had been furthest along. There was always going to be the possibility that a Native American tribe could have a casino as a matter of right under federal law. So if we tried to license a commercial casino in southeastern Massachusetts, it would be a very difficult economic decision for an investor to make, not knowing whether there was going to be another one coming along by some tribal rights sometime in the future. So the idea was to try to get a decision made early on that would make a decision either there will be a Native American casino in southeastern Mass, or if not, there'll be a commercial casino in southeastern Mass, but there would be some high degree of certainty that there would just be one. Again, you probably know all this, but just to reiterate, the tribe and the governor have to negotiate a compact that has all the terms and conditions under which a facility would be run in southeastern Mass by July 31st, and that legislation has to pass, and that compact has to be approved by the House and Senate, by the legislature by July 31st. If that happens, then the compact will become the governing document, and the Gaming Commission will not issue a license to any commercial provider in southeastern Mass, so long as we are confident that eventually the tribe will get its land in trust, the process that it's trying to go through for its land that it owns or has optioned here in Taunton in some reasonable period of time. If the compact is not approved by July 31st by the legislature, then all bets are off. Then the Gaming Commission takes over, and we will then be in the position of issuing an RFP, or what we're calling an RFA, a request for applications, for commercial licenses in southeastern Mass, just like in the other 2 regions. In that situation, the tribe is perfectly able to go ahead and bid as a commercial bidder, but they would not be having any competitive advantage by virtue of being a tribe. So at this moment in time, we are basically sitting and waiting. These are confidential negotiations between the tribe and the governor's office. Very complicated and sophisticated. The tribal governing laws are a very arcane area of the law about which not very many people know very much. There are very specialized law firms that do this kind of work. The tribes, as you well understand, are respected as sovereign nations. It's not just like negotiating with another businessman. You're negotiating with a sovereign nation, as if we're negotiating with France rather than just a business guy. So the negotiations are very subtle and confidential and delicate. But we do know this. It probably will be announced, the terms of it, sometime, possibly as soon as the next week. I think the governor's aspirations is to get a compact done and approved with the tribe in order that it can get to the legislature with at least a month or so to go. So that would mean that it would have to happen in the next week or so. I think that's the plan. What we generally know is that the governor is trying to negotiate a compact with the Mashpee that replicates to the maximum extent possible the terms and conditions and standards and values that are incorporated into the gaming law, the law that we are enforcing and implementing in the other two regions. In order to have basically a level playing field, in order that host communities, surrounding communities, casino developers, participants can get a relatively level playing field. If everybody's operating, they don't want to have, the governor doesn't want to have a situation where a host community and surrounding community, for example, in southeastern Mass are dealt with in a way that's very different from the way host communities and surrounding communities are dealt with elsewhere. So to the maximum extent possible, and this is the language from the governor's office themselves, improving the quality of life in host communities and surrounding areas while generating new economic development opportunities are priorities in both the expanded Gaming Act and in ongoing tribal compact negotiations. We are committed to finalizing an agreement with the Mashpee Wampanoag tribe that is consistent with those priorities and benefits the entire region. So that's a careful way of saying, if you want to know what the compact is going to look like, you can reasonably look to the Mass gaming law as a model, because they're trying to move in that direction. Now, I just want to say a couple of things that are clear. I know there are people from the press here, but also people who have strong vested interests here. I have no inside knowledge about what the compact is going to look like. I don't speak on behalf of the governor's office. There may well be differences in the compact that eventually comes out and the gaming law. The governor cannot control all this, whatever his aspirations might be. So I'm speculating here that because of the governor's office expressed wish to try to replicate the values and standards and parameters of the Mass gaming law in the compact, that they will get somewhere close to this. But please don't, as they say, take this to the bank. This gives you an idea of where the governor's trying to go with these negotiations. The financial parameters for the commercial licenses are the following. For any casino, there's a minimum license fee of $85 million. If we give a license to a casino operator in eastern Massachusetts, they have to pay the Commonwealth a one-time license fee of $85 million. Slots operator has to pay a one-time license fee of $25 million. For a casino in regions A or B, there's a minimum capital commitment of $500 million. You cannot come to the table with less of a smaller deal than a $500 million investment. The slots parlor has to be a $125 million investment. And the tax on the gaming revenue, the gross gaming revenue, which is the total amount of money gambled less that which is given back as prizes, as awards, as winnings. So the net revenue, gross gaming revenue, in a casino is taxed at 25%. 25% of the gross gaming revenue in a casino will come back to the Commonwealth. 49% of the gross gaming revenue in the slots parlor will come back to the Commonwealth. So presumably the governor will be trying to replicate those kinds of levels, particularly the tax rate level. They want there to be a level playing field, that the Commonwealth, through some form or other, technically you can't tax the tribal facility, but you can get payments of various kinds, and they probably will try to replicate that. For the other commissions, this is really important. For the other regions, no proposal comes to the Gaming Commission. We got many, many emails from the people of Milford saying, no, 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 we don't want a casino in Milford. Well, we don't have anything to do with the proposal for Milford or any place else unless and until a host community approves it in a referendum, approves the agreement in advance in a referendum, and only then does a proposal come to us. Sounds like the tribe is replicating that in a similar kind of a fashion for host communities. Surrounding communities is a really complicated issue, and I know there are a lot of surrounding communities represented here, and this is an area that you all are thinking about a lot. In the governor's legislation, the the way that surrounding communities are handled by, it is very straightforward. The Gaming Commission has a tremendous amount of flexibility in determining what will be a surrounding community. The developer can decide. If somebody wants to do a casino in Suffolk Downs, they can decide to deal with Winthrop or Revere or whoever. But when it comes to us eventually, we have basically unilateral authority to decide what would be considered a surrounding community. And the legislation says a surrounding community is municipalities in proximity to a host community which the commission determines will experience or is experiencing or was likely to experience impacts from the development or operation of a gaming establishment, including municipalities from which the transportation infrastructure provides ready access to an existing or proposed gaming establishment. So it's very wide discretion. Once we determine what a surrounding community is, these are the consequences for a surrounding community. The funds for impact studies and negotiating an agreement with the developer will be paid by the developer. A surrounding community has to have a signed agreement with the developer before the proposal comes to us. The surrounding community has a right to receive notice of a hearing on the application and to participate in that hearing. It requires that the commission consider the impacts on the community, and a surrounding community has the right to receive benefits from the Community Mitigation Fund, which is one of the uses of the tax revenues from gaming, to offset the consequences of the facility in their community. So the surrounding communities, the legislature did a very good job of protecting local control rights, both in host communities and in surrounding communities. If you're from a surrounding community, you can imagine that the governor will be trying to get similar kinds of protections in the compact. But as I say, there's no way to know for sure about that. There are some other opportunities for surrounding communities in the tribal situation later on in the process, which I can speak to in a Q&A period if anybody's interested. The revenues from the taxing of the commercial facilities. You can imagine the legislators who are here will appreciate this, but there's going to be this money, and I'll tell you later on, but it looks like it could be as much as $350 million to $500 million a year that will be the proceeds from the gambling revenues to the Commonwealth. Where's that money going to go? And of course, everybody wanted a little piece of it. And what the legislature, in its wisdom, decided to do was, one was to set up a community mitigation fund, two was to set up some of the money will go to a lottery fund to offset losses to the lottery that occur because of the casinos. Then they also have all the following: a manufacturing fund, a community college fund, Mass Cultural Council, Gaming Economic Development Fund, Mass Tourism Fund, Local Capital Projects Fund, Debt Reduction, Healthcare Payment Reform Fund, Community Mitigation Fund, Public Health Trust Fund, Racehorse Development Fund, Gaming Local Aid Fund, Transportation Infrastructure and Development Fund. A little bit of everything, which is a great legislative response to a problem. But it got a lot of constituencies very interested in where this money was going to go. It got a lot of constituencies very interested in supporting the gaming legislation. Now, the criteria that the legislature gave us for how we're going to make our decisions when we select developers for the other two regions. And again, you can imagine that the governor will be trying to represent these same values in the compact that's being negotiated with the tribe. First and foremost is to assure the public integrity in the gaming license process and in strict oversight. That is throughout the legislation, is mandating us. This has got to be an integrous process that the public and the participants can believe in. I will say, because there are a couple of legislators here, that we now have had a lot of experience hearing other gaming jurisdictions react to what we're doing in Massachusetts. We're the most recent jurisdiction out of 37, I think, before us that have brought gaming to their states. And we have uniformly heard that our legislature passed the best gaming law that's ever been passed. The most thoughtful, the most comprehensive, the most attentive to mitigating the host of potential negative effects. So the legislators should take pride in that. And as I said, even when Speaker DeLeo was in the room, the legislature gets beat up for a lot of things, and they deserve to get credit when they do things well. And this is one that you should know the legislature did very well. We are also mandated to protect the lottery. There's a tremendous amount of concern. We have a lottery in Massachusetts which generates gambling in the state, in the lottery, to the tune of $850 for every man, woman, and child in Massachusetts. $850 for every man, woman, and child in Massachusetts is gambled today in the lottery. $1 billion of that revenue goes back to the cities and towns in local aid, so it's a crucial aspect of local aid to cities and towns from the state. And people are worried that if a lot of the lottery money goes to the casino or the slots parlor, local aid will drop. So we are mandated to protect the lottery, meaning cross-promote between the lottery and the casinos and so forth. A very high priority from the standpoint of the legislation. Maximizing job development, job generation, and protection of existing jobs and capital investment. You can imagine, again, that would be the highest priority. When the governor asked me to do this job, he said to me that the revenue to the state would be nice, but he didn't have stars in his eyes about how much revenue we were going to get. But he did believe this could be a serious job generator and a serious economic development generator. And the legislation makes clear that that's what we are to focus on. Legislation says we need to promote diversity in the workforce and among suppliers, and this is an issue that we're going to be taking very, very seriously. 21% of the people of Massachusetts are people of color, and we would expect that similar kinds of ratios would apply to the workforce and suppliers. Legislation is very clear about protecting local businesses and the local tourism industry. Some casinos have a reputation of being sort of closed box facilities where you suck in all the audience, all the consumers from around the region, and don't let them get out to use other facilities, other restaurants, other tourist attractions, other entertainment venues. This legislation is designed to make sure that we manage the relationship with the developers in a way to protect those existing industries. The legislation says that we have to integrate gaming facilities with the unique cultural and social resources of Massachusetts. That's a pretty subtle one. I'm not quite sure how we do that, but we don't want to have facilities come in that somehow distort strengths that we already have, social strengths, cultural strengths, tourism strengths that we already have. We are told to maximize the mitigation of compulsive gambling and other negative consequences in host and surrounding communities. There's a lot of money set aside. I think $5 million a year is set aside to mitigate compulsive gambling, and the developers have to promise us that they will undertake various techniques to deal with problem and compulsive gambling. And next Monday, by the way, at North Shore Community College in Lynn, we are holding our 4th public education forum, and that will be on the issues of compulsive gambling and how we can deal with that in our job of licensing casinos. We are mandated to coordinate with regional and economic development plans. Again, you can imagine that they're going to try to replicate this in the compact, so your regional planning agencies will have an opportunity to work with the casino developers to maximize the regional benefits. Maximize sustainability principles in construction and operation. We want to have facilities that are as green as possible. And finally, maximize revenues to the Commonwealth. So those are the criteria that the legislature has already laid out for us, and that drives our work. Those priorities drive our work. Legislation also gives us some flexibility to look for other priorities, but that doesn't really have much to do with Southeastern Mass because we're not going to be negotiating a deal with the tribe in Southeastern Mass. But these priorities are in the expanded gaming law, which the governor says he thinks ought to be reflected in the compact as well. So that's kind of the lay of the land in terms of the economic parameters and the terms and conditions under which a deal probably will be struck with the tribe. I'll tell you a little bit about what we've been doing. We've been in business, I think now 10 weeks, 10 or maybe 11 weeks. I said to Joe or somebody, it feels like it's been years, but it's only been 2.5 months. We now have 2 professional staff. Elaine Driscoll joined us from the Boston Police Department, where she was spokesperson and is now our communications director. She's our 2nd professional staff. We have 2 support staff, so we now have 4 staff and 5 commissioners. We almost have as many staff as commissioners, but Considering that one of these days we'll probably have 100 to 150 employees, you can see that we're still just getting going. This does not relate to you all unless the compact does not get executed. If it does get executed, if it does not get executed on July 31st and approved by the legislature, we will be back to Southeastern Mass, because there's a whole different situation that will be going on in Southeastern Mass if the compact is not approved by the legislature. But for the other regions, we have split the RFP process, or what we're calling the RFA, request for application process, into 2 stages. One is essentially a pre-qualification stage. So if you're a developer who wants to be in the business, either of a casino or of a slots parlor, within the next couple of months, as soon as we can, we will be getting out a pre-qualification phase 1 of the process, which will require you to fill out your financial background so you can prove to the commission that you've got the financial wherewithal to be a reliable developer, and issues of personal integrity and character and so forth. So we will be doing very, very serious background checks on the financial and personal and criminal legal backgrounds of anybody that wants to be a developer of a casino in Massachusetts. And that will be their funding sources, their major equity partners. It's a very, very comprehensive process. But that will be underway soon, so the process will really start to move. Meanwhile, we will be writing the regs that will go into the detailed RFP that will go out, phase 2 of the request for application process, which will be very site-specific. In that phase, the developer will send us the host agreement and the particulars about how many cars and how big the facility and how many jobs and so forth and so on. But that will be phase 2. But it enables us to get the process going so we can winnow out any frivolous players. If there are players coming around to your community saying, we want to talk to you about putting a casino up here, but they're not really serious, they will be winnowed out at this process, because in order to be an applicant for this first phase, you have to put up $400,000. And I think that will get rid of the frivolous players. So the communities won't have to be working with anybody who isn't really for real in the business. We're working with the state agencies. This will relate to whatever happens in Southeastern Mass. We're working with the state agencies, transportation, economic development, environmental affairs, to set up expedited licensing and communications processes, both so an applicant can get their ducks in a row for telling us what they're going to do, and so that they can get the casinos up and running once this is done. We will probably appoint, once they get a license, we will probably appoint an ombudsman who will be a person in our office who will be the point of contact for all developers. If you have a problem with state DOT, you'll call our ombudsman. If you have a problem with an environmental reg, you'll call our ombudsman. And our ombudsman will facilitate the work of all the developers to try to get answers from the state. Probably that same person or someone similar to that person will also be working with the municipalities. If you are a potential host community, or if you are a potential surrounding community and you don't know how to negotiate with the developers, you don't have the money to hire a law firm, you don't know how to don't have the money to do a consultant check on your traffic impact and so forth, we will have an ombudsman in our office who will help the municipalities deal with all that. We've had, as of Monday, we will have had 4 public education outreach meetings. The first was just on the regulatory process in general. It was a day and a half where we brought people in from Pennsylvania jurisdiction and New Jersey jurisdiction and had a tremendously interesting public training session for us about the regulation business. A lot of work, particularly on the law enforcement side. Each of these has been publicly streamed and is on our website now and is open and has been open to the public. The second one was on the economic development impacts. You may have seen that we had, a week or so ago, we had a meeting of many people who have been involved in assessing the potential economics of gaming in Massachusetts. And essentially the question we asked them was, do the basic economic assumptions that got the legislature to authorize as many as 3 casinos and 1 slots parlor, do those economic assumptions still hold? Or do we need to rethink this? There was all this noise about Sheldon Adelson pulling out, saying the market wasn't a big enough market for so many casinos and so forth. The bottom line of that was, yes, the economic assumptions are the same. So the basic guidance that the legislature gave us, there's no reason to second guess that. We had a forum on community mitigation in Framingham, the Framingham Terra yesterday, which was incredibly interesting. Some of you were there, incredibly interesting, where experts who have gone through this, in some cases with other jurisdictions. There was a woman there from Henderson, Nevada. It's a suburb of Las Vegas. She was the town manager in Henderson, Nevada when 3 casinos were sited and built there. Her key line was, you don't take a knife into a gunfight. You're going into a gunfight when you negotiate these deals with the developers. You need to have the resources to do the job. There was a clear sense that from all of these experts, and it's very clear from the people in the communities as well, although your mayor seems to have handled this pretty well, Mayor of Taunton seems to have handled this pretty well, but many of the towns feel overwhelmed by the proposals from the developer. They don't know where to go. Many of them don't have full-time staff, don't have planners, don't have full-time mayors, don't have full-time, even in some cases, don't even have full-time town managers. There's not a level playing field right now between the municipalities and the developers in negotiating the host agreements or the surrounding community agreements, and we will be addressing that very quickly. Okay, so at the end, so that's sort of the background. That's what the legislation envisions. This is something what the compact will probably look like. This is what we've been doing for the last 10 or 11 weeks. What will this all look like at the end of the day for Massachusetts? This was all about jobs and revenue. That's what the legislature and the governor, and going back, Bill Weld tried to do this, 16 years ago, and as others have said, this has been talked about in Massachusetts for a long, long time. It's about job development and revenue. The legislation says nothing about the siting of the slots parlor. It can be anywhere in Massachusetts. The legislation does direct us to put out a request for applications for a slots parlor before we get to the request for applications for the casinos. I think the idea was that the slots process is a much less capital-intensive process. The minimum capital investment for a slots parlor is $125 million versus $500 million for the casinos, and the one-time license fee is $25 million as opposed to $85 million. So I think the legislature thought that we could probably move quicker on the slots parlor, and the slots developer could move quicker and get the jobs and the money rolling. We are advised that there is a relationship between the locations of these facilities, but whether it's a good, bad, or negative, whether you want them close together or you don't want them close together, those are issues that we haven't figured out yet. But the slots parlor, unlike the casino in southeastern Mass, is up to us, and we can cite the slots parlor anywhere in Massachusetts that in the end we decide is in the Commonwealth's best interest. Yes?
Is there any sort of a timeline presently on the slots parlor may be able to come to fruition?
We haven't broken the slots parlor timeline out. The stage one, as I talked about, what we're calling RFA 1, Request for Applications 1, is this pre-qualification stage. That will apply to slots developers as well as casino developers. So the moment of truth will be whenever we issue this RFA 1. Hopefully, I think we have it targeted for mid-October. So that will be the day when, if anybody's interested in the slots parlor as well as the casino, they'll have to come to the table, pay their application fee, and get the ball rolling. We are already beginning to work on the regs and the process for RFA 2, which is the more detailed development proposal. But I don't know what that will be. I would guess, I think certainly by the first of the year, I would think we would have that available, but it can take quite a while to go through the financing and background checks of the players for any developer, depending on where the sources of the money and how complicated the application is. So we won't be able to move forward on the second phase of the request for applications until we've pre-qualified everybody for the first phase. Yes?
You have a pretty elaborate mechanism to look at the financial picture of the commercial developers. Is there something in place that also looks into the financial backers of the tribe?
At the moment, no. That will be covered in the compact as well. We have no authority over the tribal casino except that which is in the compact. It's negotiated with the government now. There will be some, but exactly what it will look like, I don't know. As I said, you can be sure that the governor and the legislature who have to approve this compact are going to be looking for the same kinds of protections for the communities involved and for the people of Massachusetts in the compact as they got in the law. So all those things I talked about and all the regulatory processes that we have available to us, they will be trying to get into that compact. But how that's going to work exactly, I don't know. I think it's a safe bet to say that there will be some mechanism for some kind of vetting, probably done by the tribe, but there certainly will be some kind of serious oversight. I did want to mention one other thing. If the compact is approved, the tribe, as many of you probably know, is already in the process of working with the Secretary of the Interior and the Bureau of Indian Affairs to get essentially what become in colloquial, this is wrong technical language, but in colloquial language would become their reservation land in effect. It's called land in trust. And it would be the land where they wanted the facility to be developed here in Taunton. That process can take anywhere from a little time to a lot of time, and there are a lot of issues involved. There are legal issues. There was just a decision yesterday in the Supreme Court, the TACC case, I think it's called, PATCHAK, that gave individual citizens the right to challenge decisions about tribal gaming facilities. So there are a lot of issues involved. But when that process goes on, the Secretary of the Interior needs to make the decision that the proposal for the land in trust is in the interests of the tribe, not in the interests of the communities, and approved by the governor. So the communities that will be around this facility, as well as the community that hosts the facility, if there is a compact with the tribe, will have an opportunity to be involved in an approval process even then, because the Secretary of the Interior does need to make a decision about the impact of the facility on the surrounding community. So there's no great rush here. There was some concern expressed in our meeting, our community mitigation meeting yesterday. The towns felt like they were really under the gun to make decisions, to get things done. Even if the compact is signed, there are many more steps to be taken where people will have an opportunity, elected officials and others will have an opportunity to speak about the pros and cons of the situation. Other people? Yes?
Chairman Crosby, if you could follow up on the compact part of it. How does that reconcile with the Supreme Court ruling about tribal recognition, I think it was after 1934?
Right.
Are we talking about the requirement as part of that process for the Secretary of the Interior that we need congressional action to also take place to allow for recognition of land to be taken into federal trust land for tribes recognized after that time period?
I'm not an expert on this at all. Do you happen to know well the answer to that question, Jim? If you do, I won't even try. I'll just let you do it.
I dare not.
Okay.
There's a number of instances in the last couple of years since that case where the land has been taken into trust.
The debate is whether or not land in trust can be assigned to a tribe which was not federally recognized by 1934. The Mashpees had some kind of relationship with the federal government prior to 1934. There's a question, a debate can be made as to whether they were, quote, federally recognized by 1934. There's a Supreme Court case that did authorize a tribe that was not technically recognized but did have an ongoing relationship with the federal government prior to 1934. They did get land in trust. It's a complicated area. I do not believe that it requires legislative. It could have a legislative fix. You know, the Congress could take a position to clarify this, and that would then set a new standard. But right now, it's between the Secretary of the Interior and the courts, and it seems like there is a debate within the Interior and the Justice Department and the courts. It doesn't require a congressional fix. It certainly, I think it's certainly, given what I know, it's certainly a reasonable guess that the Mashpee can get land in trust. There's nothing that makes it a slam dunk to the contrary, but it's complicated. Yes?
Are you saying also that if a property owner does not want to relinquish their property, where this is going to be, that it can be taken by eminent domain, sort of? Is that the same idea?
I can't answer. I was not saying that. No, I wasn't saying that at all. I don't know. I don't know what the rights are relative to eminent domain and the taking. I can't speak to that. I'm sorry. Representative?
If the compact is reached and the land is not taken into trust, what will happen after a reasonable time period? And what reasonable time period is that? That the Gaming Commission is going
Right,
to?
that's a good question. If the compact is reached and approved by the legislature, and the commission then, as I think I said, will not issue a commercial license as long as the commission, and now this is not legal language, this is just me talking, basically as long as the commission believes that there's a reasonable chance that the land in trust will happen, then we will not issue a commercial license. But the law does seem to give commission pretty wide discretion to make the decision about whether or not land in trust will happen. But how we would do that, we would certainly wait for some significant period of time. But we haven't gotten anywhere close to thinking about what that might be. Yes?
So you don't know how long of a time period you would wait for the land to come into trust?
I don't. I mean, it's something we've never even talked about. People have typically been talking about land in trust could take a couple of years, so just based on what I've read in the paper, not anything we've talked about at the commission, because we haven't talked about this. But I certainly think that if we thought that there was a wait of a couple of years, I think from what I've heard, that would not be considered a barrier. That if it looked reasonable that within a couple of years it was going to happen, I think we would sit tight and not do a commercial license. If it was really open-ended, then that's when we would have to start thinking about it. Because the Commonwealth, the legislation was designed to try to make sure that Southeastern Mass had the same opportunity for jobs, fun, and money as the other regions. So the intent of the legislation would not have to have Southeastern Mass sitting on its hands for too terribly long, but I think too terribly long would be some number of years.
Thank you very
All
much.
right, thank you very much for having me.
Thank you, Chairman Crosby. I just wanted to remind everyone that we will have another breakfast next week, Tuesday, the 26th, and our featured speaker is Vincent Buddy CNC. If you would like to pre-register, you can see Lisa on your way out. I would also like to thank Chairman Crosby again for coming today. Our sponsor, Carrera Insurance and Anytime Plumbing, thank you. And of course, our host, Benjamin. This concludes the breakfast. Have a great day.